So let's kick it off. I do have to make this announcement though, because I realize we got you here maybe under false pretenses, and I take full responsibility for this. We're actually not going to be talking about newly separated spouses specifically, although there are a bunch of topics that we're going to be dealing with. But I made the mistake of announcing that when in fact we're finishing up our final set of questions. So if you want to jump off and come back when we are going to do that presentation, I completely understand, and I'm sorry to have wasted your time. If you're willing to stick around, we'd love to have you. And as we go through the final set, and I guarantee you we're finished today, the final set of questions, a number of them are really, they're all good ones. And there's a number of ones that apply to separated spouses. So hopefully you'll find it useful. Let's go. So it's thanks to Michaela. She knows where we finished, but we're on probate and administration questions. Let's go here. And the first question is such a common one about multiple wills and not using multiple wills and how probate tax is affected. So here we have this typical situation: the deceased did one will, and yet there are assets that don't need probate. And the question is, do we have to even include those assets that didn't need probate in this situation because we've got one will? And the answer, this is a test for everybody who's watched one of our multiple wills seminar, the answer is yes, you must include those, because the test for whether you have to include an asset's value for probate is ask yourself, what will am I submitting for probate? And then ask yourself, what assets are governed by that will? And if the asset is governed by that will, in other words, there's no other will that's governing that asset, then you got to pay probate tax. Whether you needed probate or not to deal with it, that's the test. Ian, anything to add there? Because that's really a common one, obviously.
No, and a straightforward answer too.
Yeah. Okay, so now we're into a situation where, matrimonial home issue. And how do we deal with that when calculating the value of an estate? Ian, do you have any off the top points about this as far as, wills? And I always make this point to my clients at the outset. I said, ownership is so important in wills, right? Who owns it? That's really the question for what will is going to be governed by that, and what estate, if there's not a will, what estate does it fall into? And my preliminary comments is we don't have a shared property regime. We do not look at a matrimonial home as being co-owned for property law purposes. Yes, there's the right of an equalization of value, but the actual ownership is not affected by family law. And so my answer to this would be the entire value, if it was owned by the deceased spouse, would be included in the value of the estate. Ian, do you have any comments on that?
No, I don't. There's nothing really to add. I mean, these are excellent questions, but they're direct responses. I agree.
Sure. And so there is the idea, maybe we can spend just a minute, Ian, because you would deal with this, on the issue of constructive trust claims against assets. So let's say the spouse, in this case, the surviving spouse, had a constructive trust claim because he or she contributed to the maintenance of that property, or any of the classic constructive trust claims.
Sorry, Jordy, I'm having trouble with my internet. Can you just carry it for a minute?
Yeah,
I'm going to just go to a different one. Sorry.
Yeah, no problem. He does this with me all the time, actually. And whenever I ask him a tough question, it's like my internet's not working. I know of one, just to share a funny story. I spoke to some kids who are at a all boys school when COVID came and everything was on Zoom, and all of the kids, all of the boys, of course, in the class changed their name to loading ... So when the teacher looked at it, it looked like all the students couldn't participate because their Zoom was still loading. So I think Ian's pulled one of those. A constructive trust claim, those kinds of trust claims would come before the entitlement of the estate. So if in fact, because of constructive trust or resulting trust, the beneficial owner was not 100% the deceased, then it would only be the beneficial ownership that would be dealt with. But that's an ownership question. That has nothing to do with the net family property equalization. When inheriting real estate, land transfer tax, and Ian, I don't know if your internet's working, but maybe I'll just keep going here. If the land was given specifically in the will to the beneficiary, there is no land transfer tax on that. Now, let's say take this scenario. The land is not specifically given away in the will, but it's part of the residue, and the residue is 50-50. And they agree that one of the beneficiaries is going to take the land and the other beneficiaries are going to take an equivalent amount of cash. At that point, there is land transfer tax triggered on that, because the LTT people look at it as if the beneficiary is buying half of it from the other beneficiary. So that's when land transfer tax might be dealt with and triggered. This is an occupation rent question. I don't know, Ian, if you're back on or not, but if I'll assume you're not, unless if you want to jump in. So this is not an unusual situation. We've got an estate where there's a beneficiary still residing in the home and rent-free, presumably. And how do we deal with that vis-a-vis the other beneficiaries? And this is one of the reasons why you might, if the testator wants a beneficiary to stay in the home, have the ability to stay in the home, to address this in the will, right? And use a residence trust. But in this case, if the beneficiary is living in the home rent-free, I think that there is a claim for occupation rent. And the question is, when does that kick in? And I would say, I don't think that the beneficiary has the right to stay in the home rent-free. Now, that being said, and this is where Ian might be able to chime in, it may well be that what that does when you say to them, oh, by the way, get out of the house and pay up, they say, no problem, I'm a dependent. And so I'm going to claim dependent support and say I'm actually entitled, as part of my dependent support, I'm entitled to stay in the home. And that's where things get, messy. But I don't think there's a period. Now, the only exception would be a spouse. So under the Family Law Act, where a spouse is residing in a matrimonial home, that spouse is entitled to stay in that home for 60 days rent-free. So that's the exception to, charging rent from day one. But I don't see that there is a right to stay, subject to any agreement that the testator had with this person, to stay in the home. And Ian, if you have anything to say, jump in.
I'm sorry, Jordy, I'm back. I'm at the office and our Zoom was freezing. So I'm back. Why don't you carry on and now I can participate?
Sure. So just any comments on this idea of, a non-spouse living in the home after death, and the idea of what's the risk of saying to them, look, you got to start paying up and get out of the house. And I just raised the issue of a potential dependent support claim.
Yeah, and it's also an optics, right? I mean, one of the best ways to manage estate disputes is to get ahead of them. And boy, when you start, if it's a de minimis amount and you start playing games like that, it's a bad way to start. You're starting off the wrong foot. So I would just say, from a practical standpoint, be very careful before you start looking for that.
Great.
That often will trigger the dependence relief claim.
Exactly. Yep. And if you're the executor, trying to keep the other beneficiaries, like it's usually, if it's not the executor who's pushing for it and it's the other beneficiaries, you just say, just hang on, like, right? Is that would be your strategy too, Ian?
Yeah, years ago when I was a young lawyer, I remember coming into Justice Doug Lissaman's court, and he had a packed courtroom, and wasn't my case, but the one before it was a dependents relief case on behalf of a spouse and a surviving spouse, and he looked around the room and he said to everyone in this room understand, every judge in the free world, widows go first.
Right. Yep.
And it's a telltale comment, right? Be very careful. What poking that bear is, judges do not like it.
Yep. And when it comes time to litigate that, if it is a dependent support claim, and you were trying to evict that person, who was, that's not gonna, when I say you, the executor, it's not a great look.
It's not good form.
Yeah. So tell me, let's talk about interim distributions. So what do you need as far as a release and indemnity? Do you want to speak to that, Ian, or you want me to lead off?
Sure. Yeah, you can lead off and I'll add.
So I guess it depends, the size of the interim distribution. So, if you haven't produced an accounting with the interim distribution, then asking for a release is, what are they releasing exactly? It's probably not worth anything. So, I had an estate, I made an interim distribution. Here's the check, here it is. As long as I'm holding back enough money that I've got some leverage as the executor to get that release when I make a further distribution, and I didn't have the accounting ready, and so here's your money, like here's some money for you. I shouldn't be holding it all. I didn't ask for any kind of release, and I was satisfied not to ask for an indemnity, to pay that money back, because there was enough money there. So I think it's a judgment call. Again, asking for a release without an accounting, I'm not sure that makes much sense. What would you do with that, Ian?
Well, I agree. I don't think I think there's your point is dead on from a practical standpoint, but let's look at, think about it like a lawyer, and a release without any information isn't going to be enforceable. Typically. And number two is, at the end of the day, the courts are and it came up probably 15 years ago, Judge Shear did one of the early decisions on this. They are very, very upset with executors who will not distribute money as fast as they can. And they will say, look, if there's enough money back there, a sufficient holdback that makes sense, you've got to get the money out. And you could be easily criticized for not distributing interim distributions to beneficiaries. And if you have the indemnity, you have an automatic right of indemnification at law anyway, but you in the right circumstances, obviously. I mean, you're not for your own mistakes. So, if there's enough money there to feed an indemnity anyway, I agree with you. Let's be practical. Get the money out as fast as you can. What I find is I give them full information on the accounting, and I ask for the release and an indemnity in a standard form, if you like, and they almost always sign it because information is gold. So, I just think people have to be very careful about that's executors' arrogance when you will not distribute the money.
And nothing keeps you off, they're off your back as an executor than giving them some money. Like, getting probate and how long it's taking now, this is taking, it's a kind of a moving target here. I think it's faster than certainly at the beginning of COVID. It's much faster. It was taking, 10 to 12 months, I think, in some jurisdictions. I think right now we're getting it back in 4 months, some faster. We're doing electronic, filings, etc. Different jurisdictions do different things. And as Doug Downey said when he was on here with us, they're spreading the work out so they can do the work from anywhere. And the more populous courts where there's more filings, are sharing the work with ones who are less busy. So I think, I'm not sure I can give you an average, but my experience is, in the 4 months. And if anybody wants to chime in on the chat, feel free on what their experiences are. this goes to, legal fees. So Ian and I have two different ways of dealing with this. I do a flat fee for probate applications. And I'll share with you, it's $4,000 to $5,000. And I do that range because, it may require more work than, there may be additional, you may charge more if there's going to need to be a dispensing with the bond or finding the affidavit of execution or those kinds of things. Ian, do you have thoughts on that?
Yeah, I actually don't typically quote a fixed fee, but I try to keep it in that range, subject to, like you say, if there's extra steps that are significant and were unforeseen, then I'll add more. But I don't actually fix the fee, but I will definitely write off if I need to make it. Rarely can you justify a $10,000 probate.
Right. Yeah, and that's the other thing. I think this is a market one, and how your office is set up for probate. Now, administering the estate is a whole different thing, right? And then you get into the issue of what's executor's work and what's legal work, and you're not going to be able. And the advice that we always give, I would think, is that if you're a lawyer who's doing both jobs, you're acting as an executor or you're acting as an agent for the executor, as well as legal counsel, that you separate your dockets so that you can say, okay, this is legal work and I'm going to charge my legal rates for that. And then this other part is going to get charged and it's going to come out of executor's compensation, right? So if I'm charging on an hourly basis, and I've got a client who's agreed to pay me my hourly basis, even though it's going to be coming out of their pocket and not the estate, that's the route you might want to take. Ian?
Yeah, I agree. And the delineation isn't that complicated, right? It's pretty intuitive. And the courts have been pretty harsh on lawyers that don't understand that delineation and try to double count in that sense. If you're going to the bank to deposit a check, you're not a lawyer. That's all there is to it.
Yeah. Bonds. So the first one is easy to answer. That is, the small estates rules do not require bonds typically. So that's the first thing. I hope I'm right about that. The second thing is, how do we deal with bonds and dispensing with them? They're actually pretty easy, in my experience, to get rid of bonds, the requirements of bonds. If you show a court that, look, here are the intestate heirs, and they all consent to waiving the bond, and there aren't creditors. That's the key, right? It's not just that the beneficiaries are okay, but there's not, some major creditor. That's really, going to be the key there. If there are a lot of creditors out there, or the intestate owned a business and ran a business, then, I think you probably will have to file a bond, and there's not much that you're, again, it's hit and miss, who's sitting happens to be the judge who gets your file, right, Ian?
Yeah, and the key is, the judge has got a checklist. Justice David Brown, as he then was, made a decision years ago and sort of set out what is expected on an application to dispense with the bond. And all judges I know who do that work have that sort of checklist in front of them. And the main one, of course, is creditors. You've got to satisfy the court that there are no creditors. Otherwise, you're just not going to get over the hurdle.
Mm-hmm. Mm-hmm. So, so that's I think that's the bonding issue. And one day we'll get rid of bonding, probably, because if your executor lives in the US, they are a non-resident and a non-resident of a Commonwealth country. And so they would need to post a bond. So, those are easier to dispense with in my experience as well. Right. So what happens if you're dealing with an estate and, look, there's expenses and we can't pay, and there's no one to pay them? You can't access the estate money. What can you do? Ian, any thoughts on that?
Well, it's really is difficult, but The first is you beg the banks and see if they'll agree and identify the expenses that are needed to be paid. And my experience is that 9 out of 10 times they'll agree if you present it to them with some information and not just sort of pick up the phone and say, do this or else. Sort of a little bit of honey helps in dealing with the banks. Another thing too that I always tell my clients is that just be careful that if are you going to be in a situation where liquidity, because there are going to be some instant expenses, and there's it might not be a bad idea to have $10,000 in a joint account with someone, or it might not be a bad idea to prepay your funeral, those kinds of things, so that there's not that instant tension on the cash flow.
Yeah, I mean, using a joint, if you know there's going to be expenses, setting up a convenience account, a joint account held with someone else, and with a trust declaration that it's really part of the estate, that might be another way, obviously, to fund those things. It'll pass automatically to the surviving joint tenant. They can use it to pay estate expenses. I just want to clarify one point as far as the bonding goes. So the bonding rules for small estates, there are bonds required under certain circumstances. So just check that, especially if there are minors. So just double check that. So let's go now, Ian, and we have 10 minutes. We're going to finish up today. So the first thing is forgiving loans. This is a big issue. One of the places where people get in trouble with even the simplest wills. And it's a question I would regularly ask clients to see if there are loans that need to be forgiven in the will, because if there's a binding loan, a legally enforceable loan, then the executor has to collect that unless it's forgiven in the will. And so, that's something obviously to really discuss with your client. Let's move on to RSPs. So there's a couple of schools of thought here on whether you put the RSP designation, and I won't speak about life insurance because I'm going to just speak about RSP designations. RSP designations in the will themselves, or put them in a separate document. Well, we can talk about both RSP and life insurance. Typically the RSP, I include it at the beginning of the will, right? So it's not part of the will technically. It's the declaration. It's a designation of beneficiaries, not part of the will. So at the very beginning, and if you use e-state, you'll know it goes at the very beginning, because rarely is that a complicated designation. Life insurance, and you don't need to share that necessarily with the companies right at the top. But life insurance, I like to use in a separate document, especially if there's multiple life insurance policies, where I can send them to different places without other people knowing. So that's my personal practice, but lots of people put both those designations in the will or put them both in separate documents. So I don't know if there's a right way or a wrong way, but I'm just going to skip that and deal with a couple of RSP issues. Ian, any points on RSP trust? The idea that, yes, life insurance, you can designate a trustee, but can you do that for an RSP?
Well, there's been some bouncing back and forth a little bit on the case law. I think at the end of the day, I would say unhelpful confusion, certainly in the past 5 years on this question.
Yeah, I'm always worried about, the fact that the Act doesn't specifically allow you to appoint a trustee for RSP proceeds. I haven't run into any problems with it per se, but I think if you're going to do it, that you have to, I would want to warn my client that this may not work because there's still not, there's no clear authority for appointing a trustee for RSP, and make sure it makes sense to do it based on, if the whole idea is probate tax, you got to have a pretty big RSP for it to make, that much sense to do.
That's right.
RSPs and RIFs for blended families. So, this is a real problem because there's not, if you can't make a conditional gift of an RSP or RIF and still get the rollover. The spouse has to be the beneficiary of that RIF, and they have to roll it into their RSP or RIF for them to get the rollover. And so if, you know, the general rule is that the spouse, if they don't do that, and they trigger tax, the tax slip is going to come to them in their name. Now, that being said, the estate is jointly liable for that, but the slip goes to the spouse. If you do have an ability, that is, your spouse is also getting something under the will, then yes, you can, you know, adjust that based on it. I put in a clause typically that tells my estate trustees to make sure that they designate and elect to have that a RIF taxed outside of the estate. So that's something actually that we're building into eState shortly, when it sees that that you're designating a spouse as beneficiary of an RSP or RIF, but not the sole beneficiary of the estate. So it is something to. But the problem sometimes is that's all they're getting, and if that's all they're getting, there's nothing really that you know, no way to adjust anything else. So you might have a domestic contract is a way to deal with it that requires them to do that. And I think our final question, second final question, do we need to always designate RSPs and RIFs and TFSAs in the will if the designations are up to date? Ian, do you have any thoughts on that?
I guess the short answer is no, if they're up to date, but they're often not up to date, and it's safer drafting. Sometimes it's just included in the will.
Yeah, it's, you know, I guess the question is it crucial to the distribution of the estate? You know, I'm not sure if it's crucial that I would just, you know, let the client, you know, satisfy themselves. I mean, if you are going to do that, you know, our reporting, for example, you know, eState, our reporting letter would address that if you're not doing RSP designations in the will, and it knows if you are or not. So, you know, I don't think you have to, as Ian says. We've got obviously a lot of questions on RSPs, and this is one where, again, the burden of tax. There's nothing that's going to bind CRA as to where they're going to get their money. They're going to get their money. They're going to go to the estate first to get their money. And even though both the beneficiary of the RSP and the estate are jointly liable, the general rule is that they go to the estate first and say, give me the tax on the deemed inclusion of the RSP in the testator's terminal return. And so, you know, it's very difficult to deal with unless your beneficiary of the RSP is also a beneficiary under the will, in which case you can, like we said about the second spouse, you can adjust it using a hodgepodge type clause that says, you know, deduct any tax that the estate is bound to pay resulting from that RSP. So, but I wouldn't rely on, you know, CRA is not going to worry. They're not going to be bound by anything that you do.
Yeah.
Right, Ian? That's
exactly the problem. So the careful planning here, because, you know, CRA will simply ignore it.
Yep. And again, just to do a plug, eState monitors that and reminds you of that issue. So the last question that we're going to deal with, and then that's it for you for questions until the next time we do questions and solicit questions, is, you know, joint owners for convenience purposes. How do we, you know, confirm that it's not a gift, but it's to be held on a resulting trust? Should we put that in the will? Should we do it in a different document? What would you recommend, Ian?
Well, I personally tell my clients to put it in a standalone document. You can also include it in the will, but that creates its own problems. A standalone document does make it clean.
Right. And the other thing is, the reason I like a standalone document is I'd like the joint owner, the other joint owner, to acknowledge that they are holding it on a resulting trust. And remember, if this is being done for probate tax planning purposes, that it does not work unless you have a secondary will to deal with these assets that are held on a resulting trust, right? So,
All right. Well, thanks so
thank you.
much, Jordy.
You bet. Thanks, Ian. Thanks everyone for sticking around. I hope we added some value and answered some questions that you might be thinking of. Next week, we start with a brand new topic in our usual form, and it won't be from user questions. And hope that you'll join us again next week. Thanks so much, everybody. Have a great afternoon.